I am indeed here to focus primarily on the Commission's plans for Digital Fairness Act. We already had the opportunity to present the results of our recently concluded Digital Fairness Fitness Check to the members of the IMCO committee this November. And it's a great opportunity today to zoom in more specifically to the aspects that pertain to the protection of children as consumers. Now, our fitness check, as most of you know, focused on three of our key consumer law directives, those on consumer rights, unfair commercial practices, and unfair contract terms. And amongst the many elements that emerged from this evaluation, one very clear point was that in today's digital environment, there is a growing mismatch between what we traditionally consider to be the concepts of average, vulnerable consumer and today's digital reality. Age is, of course, already recognized as a category of vulnerability, but we often see that our rules do not sufficiently focus on the vulnerabilities of children and minors in practice. We know that these are very active consumers, they are digital natives, so this is an aspect that we intend to pay particular attention to when we design the Digital Fairness Act, and something that, as you mentioned, Chair, Commissioner McGrath stressed unequivocally during his confirmation hearing already. Now, coming quickly to the content of this future Digital Fairness Act, the mission letters addressed to Commissioner McGrath and to Executive Vice President Virkkunen already point clearly to four key areas, building on the findings of this fitness check. And all four of these areas bear a direct relevance to the protection of minors and the issues that we have been discussing today. First, addressing dark patterns, which have been mentioned a lot this afternoon. We know, and it was mentioned with the use of several examples this afternoon, that children are particularly susceptible to some of these techniques that seek to pressure and manipulate them as consumers. Scarcity messages that create the impression that this is a once-in-a-lifetime deal, that unless you press it on a button in the next 30 seconds, you risk losing it. Or gamification features in online marketplaces are typical examples. And over 60% of consumers reported having experienced such messages and scarcity prompts in our analysis. So in the Digital Fairness Act, what we want to do is see whether we can move beyond the general principles that are currently contained in our consumer protection laws, notably the Unfair Commercial Practices Directive, and see whether there is a need to clarify more concretely in the law which concrete dark patterns are prohibited. Second, addictive design. In our evaluation, roughly 1 in 3 consumers reported spending more time or money online than they intended to, and this is a result of techniques such as autoplay of videos, features encouraging infinite scrolling, rewards for continuous use, or even penalties if you don't stay online long enough. So we know that children are particularly sensitive, once again, to these techniques, and therefore reducing their exposure to such harmful functionalities will be a priority for us. And I was personally touched very much by the call of the UNICEF Youth Ambassador to say, I'm scared by the amount of my life I am spending online, so clearly heard. Third key category of issues we're seeking to address is unfair personalization. Now here I stress unfair because of course we acknowledge that consumers can overall find personalized offers and content quite useful. However, what we want to make sure is that their vulnerabilities are not used to exploit them during their weakest moments. And I should stress that the bar needs to be even higher when we are talking about children, of course. We have to protect minors from being targeted online, and one clear option we are going to look into, of course, is whether we need to extend some of the prohibitions that are already contained in the Digital Services Act, as mentioned by Irene, when it comes, for example, to targeted advertising to other types of traders beyond platforms. Finally, when it comes to influencers, and there has been a lot of talk around them as well, we know they have a huge following amongst minors. Our digital fairness fitness check highlighted that hidden marketing amongst influencers remains widespread. A very big percentage of consumers reported still not being able to distinguish what is paid content, paid advertising, and what not. There are rising concerns about the exposure of children to aggressive marketing of unhealthy food and beverages, vaping, alcohol, all kinds of issues. So we see certain member states already take legal action in the area of influencers, and we see the Digital Fairness Act as an opportunity to avoid fragmentation and set clear rules. There are many more issues that the DFA impact assessment that is only just starting is likely to address. I mentioned, for example, problems relating to digital subscriptions, digital contracts, but I think that the examples that I've mentioned so far provide you with at least a first idea of the types of concerns we are seeking to address. Now, I'm mindful of the time and I'm coming to my last minute. I would like to leave you with three more general considerations when it comes to the way forward on the Digital Fairness Act, on issues that have already been brought to our attention by several stakeholders and, of course, the members of the European Parliament. First of all, that the Digital Fairness Act is, of course, first and foremost a consumer protection instrument, but we also see it as part of the Commission's competitiveness agenda. What the fitness check showed very clearly is that the consumer detriment from these problematic practices is very high, at least 7.9 billion euros a year, and it is notable that the biggest detriment is actually suffered by younger consumers. So our supporting survey really showed that the age group 18 to 25, that was the youngest group we covered, faced problems in 73% of the cases, and that is more than any other age group. So our young consumers are losing time and money. This is something we want to address, while keeping the compliance cost for businesses very low, as is now the case and has been proven by the Digital Fairness Fitness Check. So we don't want to introduce reporting requirements where we don't have to, and we will seek simplification opportunities where such possibilities exist. Secondly, we know that there's a certain degree of regulatory fatigue in the EU, that a lot has been adopted in the previous mandate in our digital rule book, and Irene, my colleague from DigiConnect, showed already that this is producing results. So with the Digital Fairness Act, as underlined by Commissioner McGrath, we are not seeking to reopen recently regulated issues. We are not seeking to duplicate. We are really aiming at targeted interventions, addressing gaps and areas where there are uncertainties in legal interpretation. And my very final point, which was also the one that Irene made, the Digital Fairness Act is, of course, only one piece of the puzzle. There are many work strands in the Commission and in DigiJust, where I come from. I know that my colleagues from the units responsible for the protection of the child and the rights of the child are also following this debate. We are working on an EU-wide inquiry on the impact of social media on adults, on an action plan on cyberbullying, on the follow-up to the EU strategy of the rights of the child. So the DFA is only one piece of the puzzle, and we will be having a public consultation of it this spring. Looking forward to working with you on it.
Thank you very much, Mirto. Just one simple question. When do you think is the DFA going to be launched by the Commission? I mean, I don't need an exact date, but it's going to be launched in the 25th or in the 26th. I mean, are you working to...
We are working on the basis of launching the preparatory work this semester, so in spring 2025. We want to go through the full process foreseen and allow for a proper public consultation and thorough impact assessment. So speaking, of course, under the control of my political masters, I would say that the DFA will not be presented before 2026.
Thank you very much, Mirto, and it was very interesting to hear from you, and we will try to go back to you with a Q&A time. So next, from the video game industry perspective, I would like to give the floor to Jürgen Bänsch. I don't know if, how do you say your last name? Oh, no, your last name. Oh, maybe it was... he's Senior Director, Policy and Public Affairs of Video Games Europe, which is, as you may know, the association representing the European video game industry. Jürgen drives the public affairs agenda across key policy areas like minor and consumer protection, but also data privacy, e-commerce, and platform regulations and education, among others. Jürgen's previous professional background includes positions in the European trade and telecommunications sectors. So, Jürgen, you have the floor.
Thank you very much, and thank you for inviting me to speak on this panel on behalf of Video Games Europe. As an industry with a large user base under the age of 18, we have obviously a long-standing commitment to minor protection. Over the years, however, the focus has shifted. Before, the focus was very much on the protection of minors, period. Today, we speak almost only about the protection of the rights of children. And that represents quite an important change. I like to refer to the United Nations General Comment number 25, which identifies 4 general principles that need to be taken into account when you implement children's rights in a digital environment. So this document speaks of the right to development, the need to always ensure the best interest of the child, which is cited a lot, of course, but it also speaks of the right to have equal and effective access to the digital environment and the right of children to be heard in matters that affect them. So what does this mean? This means that companies need to consider not only the risks of potential harms, but also the opportunities that are associated with children's engagements in the digital environment. And that is a very nuanced approach that requires some balance. In particular also, it would be important that this nuanced approach is being included when new legislation is being proposed. For instance, when we discuss about the concept of vulnerability. In other words, solutions that are being proposed must be proportionate to the identified risk, but also to the intended target audience. If not, there is a clear risk of exclusion of children. There is a clear risk of children's fundamental rights being negatively affected. So this nuanced approach is reflected in the way we have built our own minor protection framework. Basically, it consists of 4 different pillars. We have age ratings, we have online safety, parental involvement is very important for us, but also information campaigns to the general public. The backbone of our framework is, of course, the PEGI age rating system. It is a system that we have developed together with the member states and with support of the European Commission. It informs parents about the suitability of video game content, and it does that through age labels and content descriptors. It is based on a code of conduct. It spans almost the entire sector. I think we have now more than almost 3,000 member companies that signed up to this code of conduct. The ratings are not provided by ourselves or by the industry. They are provided by official authorities in the Netherlands and in the UK. It is, as I said, integrated with support of the member states. It's integrated in the legal framework of some of the member states, and it is overseen and managed also by a PEGI council with representatives of the national member states, of the national ministries, as well as with a representative of the European Commission. The age ratings themselves, the rating criteria, are overlooked by a board of academics, which are independent. They're not paid by the industry. There is also a complaints board, which is also independent, that can hear complaints and issue sanctions. All of this frames a certain list, I would say, of age-appropriate design criteria. And so what companies will do, they will develop their video games with a specific age band in mind, so that not just the video game content, but also the narrative, basically the whole experience is appropriate to a certain age band. In addition to that, in 2009 already, we expanded the code of conduct to include certain requirements for online safety. These are more horizontal requirements, but they have been included and enforced on the industry since 2009. Some of them are quite similar actually to those that were adopted in the context of the DSA. These, for instance, relate to takedown requirements for unsuitable content, the need to have reporting mechanisms, the need to have community standards on video game online environments. So as I said, companies will target for a specific age band. However, it's also important to note that what is appropriate for a child of a specific age is not always also appropriate for a child of another age. This is because the literature levels, the maturity levels of children can vary. And that is where parents come in. I'm totally agreeing with the statement that the focus should not be on the parents, the focus should be on the platform, on the industry. But however, safety measures are all more effective if parents are involved, and that is just a matter of fact. Parents have a unique position to provide guidance to their children. They can empower their children, but they need to be empowered themselves first. And that is why our industry actively promotes the involvement of parents. First of all, through the development of parental control tools that was discussed earlier as well. These tools allow parents to agree with their children on certain rules and enforce these rules upon their children, including screen time, managing screen time, including also managing spending, right? So all of these parental control tools allow to block spending or limit spending to a certain amount. We are also conducting awareness campaigns in 16 member states, really to inform parents about the PEGI system, about the potential hazards within video gaming, but also about the parental control tools and just general information on how to reach out to your child and make a connection also about what the child is doing online, and why not play together games with your child. We believe that that is very important, and also we believe that there should be more attention to the very specific position of parents, potentially also within the legal framework. Now let me finish with a few thoughts on the future DSA. We think that one thing that the fairness refit has showed was that there is a clear lack of enforcement as well. And we are risking getting into a situation where new legislation is being proposed, while we haven't seen necessarily all the necessary enforcement of the existing rules yet. And we believe that that is a very worrying trend. It is important, we think, that there will be in the future also effective enforcement and a coherent guidance for companies. At the same time, we also think that the existing European consumer protection acquis is still very fit for purpose because it contains a number of high-level but also technology and sector-neutral principles. In fact, they allow for interpretations that can address most of the issues at stake today. And so what we expect from the new laws, the new regulations, is basically the same approach. We want to caution against rules that are highly concrete, that are very one-size-fits-all, that function maybe well in a certain environment, in a certain sector, but would not function in another one. That, I'm afraid, will end up leading to less protection instead of more protection. I will stop there. Thank you very much, and I'm looking forward to your questions.
Thank you. Thank you, Jürgen. Just also a small question that maybe you can answer later or not, but or maybe now. But the thing is that, for example, from my perspective, my children, they just change from play with their console to play with their devices. So now I have less control that I used to have with them. And also, now they play connected with others The idea is very good. They can play with friends that are not physically with them, but maybe they are playing with people that they don't know because they think there are people that they can trust. So those are things that, in my opinion, are a risk. We have to worry on it, but maybe you can answer it in the Q&A, or if it's a short answer from your side, you can do it now.
There's no easy solution, of course, but parental control tools are available also on mobile phones, of course. There are technical systems where you can install an app on your own phone and therefore have a connection with your child's phone. It's also a question of how much do you trust your own children, of course. How much do you want to control them, which is a very vertical approach. Many parents also choose to trust their children, have a conversation with them, inform them about the risks and hazards of contacting people that they do not know, but letting them to do that, letting them to make mistakes. You know, it's basically a question of parenting. You know, so there are certain things that industry can do, but real parenting is something that we cannot do.
Okay, thank you very much. Maybe we can go back to this later. Okay, our third panelist is Constantin Gissler. He is the Director General of Europe, which is, as you also may know, the organization representing the leading internet companies in Europe, including Apple, Google, Facebook, TikTok, and Spotify. Leading companies in Europe, it doesn't mean European companies. I mean, it's just to clarify that. He has significant prior experience, including time as a parliamentary assistant in this House, the European Parliament, working on IMCO, ITRE issues, and as well as in the tech association. So, Constantin, please, you have the floor.
Thank you, Mr. Arias, and thank you also to the EPP for inviting me and organizing this today. Yes, .Europe represents a lot of the leading companies, but I would argue we actually represent most of the popular services in Europe that are used by many Europeans, among which, of course, also a lot of minors. And that also includes a lot of mid-cap firms, a lot of the smaller services, even if they still reach often millions of people. I think that's really important also to keep in mind when you think about some of the responses that we're here discussing. Now, it's a little difficult to follow up on already one industry speaker here and one in the prior panel, so bear with me if I repeat a couple of points. As has already been said also by the UNICEF youth ambassador in the beginning, the internet has a lot of opportunities. It's a space where you can create, you can connect and learn. But at the same time, we realize it comes with risks, and these are inherent often in the design of the services, and also in the interactions of humans also online that translates from the offline world into the online world, and often bears the same harms there. Now, the risks are very diverse. We've heard that also in the beginning. There's many different risk vectors also. It can be harm stemming from the design of the services themselves, of course, but there is also harm coming from users between them or malicious third parties. So I think that's also really important. Again, there is not a silver bullet. Apologies, that was very, very loud. There's not a silver bullet to that, and we always need to look at the actual problem, at the actual risk, and then tailor the response to that. And that's why sometimes very prescriptive rules are difficult to find. Now, we are already doing a lot in the industry, and I know not everything is already up to the test that rightly is set to these companies. I think there is a legitimate scrutiny of all those practices. We know there are impacts, and we're also glad to see that the European Union and the Commission is now putting resources into actually studying these effects, because we think that there is need for more facts and evidence also before we have this discussion. But I think overall, and we've heard this before, it's an effort also that where several stakeholders need to come together. We see parents, of course, have mentioned educators, the governments, but of course also the companies. They need to be more proactive. But a lot is happening already. Some of the best practices have been mentioned across the first panel already, and also a little bit here. So I might repeat a few of these points. Age-appropriate design is increasingly something that we see in services. Some of the newer platforms have already built this in from the beginning on, and many of the existing platforms are moving towards these things. You see simpler interfaces for minors, you see limited data collection for minors, also, of course, keeping in mind the DSA, which I'll come to later on, and where priority is given to safety features. Content and age restrictions or feature restrictions via, for example, teen accounts is something that we're seeing increasingly. And of course, parental control tools still play a role. I know that in the beginning, maybe often these were circumvented, but I think they've also become much more robust. I've heard some of these anecdotes before, and it may still happen. My mom uses my birth date sometimes as a password. If I were a minor, that of course would unlock the phone for me and often would give me the opportunity to maybe change settings. But if my mom were to move, I mean, she doesn't do this anymore for me, but if she were to move to two-factor authentication with a thumb press, that's actually safe. So I think there's a lot of learnings that we've had already over the last 5 to 10 years, and the systems are becoming better and also more powerful, also in terms of the choices that parents are getting over the experience of their children online. So I wouldn't quite write it off yet. Of course, it's just part of a package. It needs to be part of a mix. We also should talk about technology. There's a lot of talk about AI at the moment. Of course, there's some discussion about the risks, but also the potential here that we have in reacting even faster, removing content even faster. We have, for example, some of our members have tools where between users, when they write messages or post something, it gives you an indication already, this might be a little bit harshly formulated. You might want to reconsider. This might be harmful for other people. It doesn't say that it actually stops them right there. They still need to think about it, but it gives them an indication. And I think these things can help. It's little features that can actually increase the quality of our interactions online together. Now, there's a huge variety of these tools already, and many services will employ different ones. There's also a lot of testing still happening out there. We see best practices crystallizing. I think that's also where the guidance from the European Commission will come into play, because they will list some of these things. They will say, hopefully say, what is appropriate for which types of risks, for which types of services or features. That's what we're waiting for. Back to my point earlier on, we do not only have large companies, we have also a lot of smaller companies that have not enjoyed the constant regulatory dialogue with the European Commission over the first year of the DSA. Many of these companies have waited for the national regulator to be set up, to be properly equipped. They were not there. By the time the DSA entered into force, I think roughly half the member states had an authority for it, which means a lot of these non-VLOS companies did not have anyone to talk to. That's why I think especially those companies are eagerly awaiting the guidance on minor protection, because, as we've heard, the article is very broad. And filling it with life, especially for smaller services, will be key here. Now, for the future, that was already my future. Of course, it's a little bit hard for us to discuss the future from a regulatory perspective when the law that is really the core for us, the DSA, has just been adopted such a short time ago. For many of our smaller members, it's basically been enforced for 1 year. We've just seen the first round of risk assessment reports and also the audit reports. So I really urge you, get out there, read these things. They're really long. They will set out a couple of challenges also for platforms, things they need to address. But I think we can already see there's a discussion happening, and this discussion happening also with the European Commission. The DSA, and that's where I would point to the future, is a dynamic framework. It's a breathing regulatory framework. It can actually react to future challenges. We've heard that already from the Commission representative on the panel before. It doesn't necessarily mean that the rules need to be super prescriptive in order to react to new risk vectors. I think that the DSA is actually well equipped for that. Plus, we have also now the staff at the European Commission. The expertise is being built up. We've heard about the algorithmic expert center down in Spain. And I think that shows that we're going in the right direction. Now, whether that translates also then into the impact, that's a little bit what we need to see over the next couple of years. I see that there is some frustration sometimes that we're not seeing the results quickly enough. But I would also urge you to wait maybe a year, maybe 1.5 more years to see what actually comes out of the DSA in the end before we start rushing again at new rules. The DFA may plug some gaps, as we've luckily already heard. The primary issues with online services and online platforms have actually already been addressed with the DSA. Recommender systems, ads, minors actually are not supposed to receive any profile-based ads based on their personal data. That's a thing of the past in online platforms under the DSA already. And now that needs to be enforced, of course. And I think that then final point on the DFA, what we've seen in the refit report was, of course, a couple of issues where the law is a little bit more vague, but on the other hand, also a lot of enforcement lack. We see in big member states, the Netherlands, Germany, France, and Italy, enforcing a lot more than several of the older, the smaller member states. And that's partially also where the problems stem from. We have the rules, but we now need to enforce them, and that, of course, also means equipping the authorities with the resources and expertise for that. So I might just close it here. Thanks.
Thank you very much, Constantin. Just also a very short but a question that you can maybe answer or not if you decide to answer it. Do you
Do you have a choice?
Do you think that the DSA and DMA is against the platforms that you represent, or is a legislation that goes in favor of the whole thing? I mean, consumers or users and also the companies.
I think that the DSA is there to basically protect everyone. I think also for the companies itself, it's good to have a framework that sets out the rules. And I think especially the mechanism of the regulatory dialogue with the European Commission and with the national authorities is actually a positive thing. We don't see success in a regulatory framework because of the fines or sanctions being taken, but that the services actually work, and that's what's supposed to come out of the DSA now. So I think it's the right instrument, and that's certainly what we should build on over the next couple of years.
Thank you very much. So let's go to our last, but not least, panelist, Linda Barrington-Leach. Wow. She is the executive, this one was the easiest. She is the executive director of Five Rights, a charity that works to create a digital world that is safe and designed for children. Linda has a prior experience in strategic communications and combating disinformation at the European External Action Service, as well as in the EU advocacy for human rights with non-profits and as a consultant. So you have the floor.
Thank you, Pablo, and thank you, Dora, also for organising this. I think, at Five Rights, we're really, really grateful that the EPP and also IMCO and the Parliament in general is very committed to this issue and to taking action. I think that, as we've heard today, if you have kids or if you work with kids or even young adults, you will be aware that this is indeed, as we've heard, one of the most urgent issues of our time. And thankfully, I think what's important to note is that it really is an eminently solvable issue. So, Pablo, you asked at the beginning, is it already too late? And I would say, well, hopefully it's never too late, but no, it's not too late, but time is of the essence, and we mustn't let it become an issue that is so entrenched or that it gets so complicated that it's really, really difficult to solve, as we see with other systemic issues. The European Union has recognized that this is a crisis created by the commercial choices of, in particular, a few companies, and one that can be addressed by addressing the industry regulatory framework. So we really must be clear, this is not about stymieing innovation. It is not about impeding free speech. It's really about basic product safety and normalizing some basic practical processes in product design. So let's not be distracted by highly politicized arguments fobbed off with claims that it is too complicated or will never work, or endless delay tactics from a sector that is investing very heavily in lawyers as their primary response to compliance. And as a sector that represents about 25% of GDP, when we talk about, can we match those kind of resources, the answer is probably not. So we're going to have to do something differently. Safety by design and default cannot be reduced to age verification and parental controls and reporting tools, or even one of those. It is disingenuous for certain large tech companies to suggest that age verification is the crux of the issue, when, as we heard indeed on the last panel, it's clear that we already know that they have a pretty accurate take on the ages of their users. And palming off responsibility onto parents and children themselves for safety on services designed to be toxic is cynical and unacceptable. Yes, we should trust our children, but should we trust these companies? Should we trust companies in general? What we need is to double down on established rights and rules and implement and enforce them. And then, yes, we need to plug a few gaps. The GDPR and the DSA offer robust frameworks, and the detailed and, I would say, proven effective codes and technical standards to ensure that they deliver for children already exist, and they are in the hands of the regulators. We must make sure that they are used. Then we must extend this approach to cover all relevant services, notably gaming, indeed, and edtech products, so not just online platforms, and certainly not just social media. And we must ensure that there are mechanisms in place to allow for flexibility and rapid intervention. Reversing the burden of proof in cases of alleged harm to children would be a start. Tech is and will continue to move fast. We have already sacrificed one generation. We cannot sacrifice another. It's first and foremost a question of political will. Finally, we need to promote a new culture of tech for good and build trust, where indeed it has been very severely undermined. That's the reason that people are calling for bans. Parents, but also society in general, do not trust anymore that these are services that are good for the next generations. Children, so it should not be a choice between outright bans and unadulterated exploitation. Children, parents, teachers, employers, and society as a whole stand to benefit enormously from innovation that promotes children's engagement and development and well-being. Tech companies, as a wider sector, also do. In just a few years, the popular demand for change for kids has exploded. Who will respond to this demand, and how can we support them? Investing in technical standards, certification, education for engineers, and the sharing of best practices would be a good start. I will finish by saying, be aware, be critical, but have courage. We can and we must do this. The fact that you are all here today, and I will tell you that just a few years ago, you would not have been here, and that all the speakers, including from industry, are talking the language of children's rights, safety by design, and age-appropriate design is testimony to the impact of a few key regulatory initiatives, not least for children's data protection under GDPR and the DSA. So again, I say be aware, be critical, but have courage. 5 Rights, working with children, civil society, experts, and engineers also all around the world, is here to help. We look forward to working with you, including on your report. And I'm on time.
Wow.
Thank you.
I think an applause for that. Thank you very much. Well, thank you very much. It was very interesting to hear from you. Just just a question for you, because I really think that we as politicians, we make an incredible mistake, and it's not to identify the problem that we have now on the table on this with minors. And we have to be involved to solve it, because the private companies, we cannot leave only in their hands something that is changing our lives. And we have to be involved on it. And I really think that we have an incredible mistake in this, and we have to solve it. We have to be very involved on it. So thank you very much for your input. I'm going to open 10 minutes Q&A. Okay, we have one there. I think that we start there. If there are something we have 2. Okay, let's start here. Please go ahead.
Hello. I'm Michaela, and I'm here as a mother of two and a former teacher. I come from a country where the downright addiction in children is just staggering. I've seen it as a teacher, and unfortunately not in my kids, but who knows? Because this is a social dilemma we're facing every day, because the other children are addicted, so where to find our friends, okay? The question is, I've been observing the differences in the level of public discussion and debate about the risks across Europe for 2 years, and I'm pretty sure there are big differences. One example, the mobile phones are now forbidden in most of the Western Europe, whereas in Central Europe, they are freely used, which means that I, as a teacher, could not basically teach because everyone was hooked on his or her phone. So what I did, which was borderline at the time illegal, I took their phones and then we started to do something serious. So my question is general. Will there be at some point, and I would really be very much in favor of that, some guidelines on screen time that the EU, as based on the example of World Health Organization, could provide to parents who are sometimes desperate because they just don't know, and we've heard that screen time limitations are the basics. And to give you an example, and I finish there, in my country you can hear scientists pushed by the media saying that 40 hours of gaming per week is fine, which if we calculate is maybe 8 hours per working day. So in Sweden, the government has said 3 hours for teenagers, which to me seems reasonable. But what to do with these disparities? I mean, these are the same kids, right? So will the Commission do something, or what are the options you other panelists see? Thank you.
Thank you very much for the question. So just you can think for an answer. I think that goes for you, but also for all of you. So please go ahead.
Thank you. My name's Conrad. I work for the Advertising Association based in the UK, but we're part of a pan-European grouping called the Advertising Information Group. We've heard a lot of different solutions protecting children. I wanted to just throw in media literacy as another to that mix. I'm a big believer that if you give the tools to parents and children to develop critical thinking skills, that can also empower people. And I'm a big believer as well that if you empower people by giving them individual agency, then they can also control more about their environment. So not to say that this is a silver bullet, but one of a number of solutions. And I'd be really happy to hear the panel's view on that. Just to also add as well that in the UK we have the Online Safety Act, and there's actually obligations on Ofcom to promote media literacy.
Thank you very much for the question. Any other question? Okay, one more, and then we can answer.
Thank you. Yes. I'm MEP András Kulja from EPP Group, medical doctor, and I also have more than 400,000 followers on social media. And I started my TikTok and Instagram channel because I witnessed the spread of misinformation, health-related misinformation on social media platforms. My channels are purely health educational, but it was a shocking experience when I started my channel and adolescents started to text me and asking questions about different diets and body modifications and even sexual advices they heard or have seen on social media, and it's really a Sisyphusian task to fight against this. And I see that adolescents and youngsters can easily access to these contents and influencers advertise these diets and really not healthy not only diets but habits and it's free, they can access to it, and sometimes influencers do this not for money, but because they believe in these things. And my question is that what are the plans to fight against these trends and also against health-related misinformation, because this really affects how they see the world, how they think about the world, and vaccine hesitancy and lack of trust in our healthcare system is a real issue and a growing issue, and we easily can find ourselves in the situation when we have the cures and the therapies, but the question is not the accessibility, but the willingness and the trust in our healthcare systems. And on these platforms can help to destroy this trust in early ages, and I think it's a very, very big problem for our society. Thank you.
Thank you very much. So just 2 comments for the one, 40 hours a week. An expert is saying that is good for gaming. It's incredible. In Spain, the experts are saying that 40 hours studying for kids is not good. So it's incredible. But for sure, they will answer on it. And well, I think that you can start. And if anybody wants to launch on answering it, please go ahead.
Thank you very much. As I said in my initial introduction, what we are able to discuss this afternoon is only a small part of what is required to address the issue of protection of minors online. I think your questions highlight the breadth of the challenges that start before us. What I can say is that from the Commission side, the issue of mental health is a top priority for this mandate. It is something that President von der Leyen herself stressed very clearly in her presentation of the political priorities for this mandate. She made sure that we will build on the Commission's comprehensive approach to mental health and that we will be launching an EU-wide inquiry on the broader impacts of social media on well-being. So the results of these exercises will inform our future action. We know that screen time, as you mentioned, is a challenge for parents, and that there are significant harms resulting from this. We have a Commission expert group which looks specifically on the well-being of children at school, and this is another element that you mentioned, the attention, yes, exactly, the impact of social media on children's attention. So there is, let's say, a panoply of actions through which we can address elements like this. On the question of influencer marketing, we already have rules in place that prohibit the advertisement of certain harmful types of content. I'm talking about, direct exhortation to children to buy products. You mentioned false claims, false health claims. This is able to cure you, and so on. These are already regulated, but what we have found in the digital fairness fitness check is that there is still a significant degree of uncertainty and content out there that is potentially harmful for children, and which is currently not covered. So, as I said, we will be looking at these concerns, for example, as regards unhealthy food products, and this was mentioned also by the BEOC colleague this afternoon. But again, we have different tracks to address this issue. The audiovisual media services work is one of them. The Commission's influencer hub that is supposed to provide comprehensive legal advice is another. So our aim for this mandate is to bring these work strands together and ensure a more comprehensive protection also on this matter.
Any of you want to jump to answer? We have 7 minutes, so we have to be... Okay, go ahead. Please, Jürgen, and then... Go ahead.
Yes, thank you. Thank you very much. Yes, I think as an industry, we never denied that there is such a thing as excessive use of the products. But I believe it's a very much bigger problem. You might know that the WHO acknowledged video game addiction in their ICD-11 list a couple of years ago. It is peculiar that they only focused on video game addiction as such and not looked at a broader perspective of, for instance, social media and so forth. I think you need to look at this also in perspective. We track consumer habits on a yearly basis together with Ipsos. The numbers we have received, and these are quite stable over the last years, is that the average playtime for video games is around 8.9 hours a week, while the use of social media is set at 16 hours a week, and watching TV is 24 hours per week. So watching TV is done 4 times more on average as playing video games. So I think we need to put it a little bit in perspective. That doesn't mean, of course, that there are exceptional cases of excessive use and that children can be hooked on certain games. But I think it's a much bigger problem. The whole society is hooked on screens today. So me personally, I sit in front of the screen all day. I go at home to relax, I watch TV, I sit in front of a screen, and when I go to sleep, I take my little screen with me. So I think this is, I'm not saying, you should accept this and this is normal, but I think the solutions cannot just come from the video game industry as such. For us, of course, as I said, we have provided some solutions to that. Parental control tools can allow you to block and manage screen time, but I very much think that this is a much bigger societal problem than just digital services.
Thank you. Linda, please.
Thank you. Just on the question on digital literacy, I think no one opposes digital literacy. Digital literacy is great. Data literacy maybe is even more interesting. But we should and we must get to the point where digital literacy and tools such as reporting are enough. But in order to do this assumes that it's a fair fight. And at the moment, it really is absolutely not. So it's not a question just of civic education, like teaching our kids, behave, be good actors online, beware of certain bad actors. That's a bit beside the point at this point. That is not what we're talking about. What we're talking about is automated exploitation. What we're talking about are features and functionalities that are designed by experts, including by intervention by psychologists, to exploit human psychological weaknesses in order to increase reach, in order to increase engagement, in order to increase your number of followers, etc., etc. So yes, digital literacy, all for it, but let's not fool ourselves. We've got to start by the basics and address the core issues first.
Thank you. Mirta, do you want a minute just to finalize this panel? Because you asked for it, so please go ahead.
I asked for 1 minute because I wanted to come back on one point that emerged in the discussion regarding enforcement, and it's something that we repeatedly hear, notably from industry representatives. Everything is fine, we just need to enforce the rules that are currently in place. And I want to be clear on this. Yes, we know that we need more rigorous enforcement, and this is a priority for us. We have a consumer enforcement initiative to strengthen the way we apply consumer law in practice, and we coordinate amongst the member states. We have a very strong enforcement architecture under the DSA, and it will be a priority for us to bring these two more closely together and ensure that we maximize the interplay between the two. It already is the case for ongoing enforcement actions under both the DSA and the CPC framework. But let's not kid ourselves. It's not just a question of enforcement. In every study that is out there on dark patterns, the numbers of websites and applications that deploy at least one dark pattern range from 60 to over 90% consistently. This cannot be because there is not sufficient enforcement. It cannot be that all these traders simply wish to mislead consumers and deliberately apply these dark patterns. It's also a matter of lack of legal clarity. And there we really need to intervene. We need more concrete laws. I very much take the point that we shouldn't get too prescriptive, and we will seek to maintain the horizontal nature and principle-based nature of our consumer law, but we also need to be brave and pragmatic in intervening where gaps exist.
Well, thank you very much. I think it was a very good end of this panel. So we have taken very good note of each intervention, and I'm confident they will be very helpful for the important work that we have ahead regarding the protection of minors online, and especially probably for you, Dora, that you are the one that is in charge of the INI report on this. So thank you very much. Thank you for panelists and your to share with us your worries, your thoughts, your impressions about what to do, and also to you for the questions and for your time here. So Dora, now is yours.
Yes. Thank you very much to everybody for your insights. We've been busy making notes, and this is just the start of a conversation which we look forward to continuing. But before we wrap up, I'd like to give the floor to our EPP coordinator for IMCO, MEP Andreas Schwab, who's not sitting up here, but he can do it from there too. And I do have a bio for him, so I can introduce him more extensively than Pablo. Dr. Andreas Schwab has been a member of the European Parliament since 2004, and as I mentioned, he's the EPP Group Coordinator for the IMCO Committee. He studied law at the University of Freiburg and the Institut d'études politiques in Paris, and obtained an LLM from the University of Wales in 2000. He worked as a consultant for the European Convention in the Department of European Affairs of the Baden-Württemberg State Ministry, while obtaining a doctorate in law and completing his second state exam. He's also a substitute member of the Econ Committee, chair of the Delegation for Northern Cooperation and for Relations with Switzerland, Norway, Iceland, and the EEA, a member of the Bureau of the EPP Group, as well as the chairman of the CDU Südbaden. He's been steering key legislation on competition policy, consumer rights, services, and cybersecurity. So I'd like to give the floor to you, Andreas, please. Thank you.
Thank you very much, Dora, and also a big thanks to Pablo for, I think, a really amazing hearing. I think you have managed to be empathic but factual at the same time, and that's quite rare in the European Parliament. I think the choice of speakers that you have found has been really perfect for this way of addressing the issue very early. And some of the speakers have said that we should address the core issues, and I think that has helped a lot today. And you did that all together in a very calm and at the same time concentrated way, and I think that's the way forward on this very delicate topic. So apart from this very positive mentioning, I would like to conclude also on some points on content. I think there can be no doubt that platform can put our children at risk. And I would say that we can conclude that all children are living at this risk. It's not only vulnerable children or vulnerable consumers, it's everyone. Because every child can fall into a situation where that risk of addiction for whatever content they like to watch is there. And therefore, there is a responsibility that we have to face that can probably partly be addressed with the existing legislation of the Digital Services Act, but there are issues, we have heard it today, that go beyond. And therefore, I think the hearing has shown that we in the EPP, we will check very precisely what lacks there are and where we have to go further. At the same time, this task cannot only be a European task. I think the examples that you have mentioned from Hungary or from other countries, specifically mentioning Eastern issues, I think there are also Western issues, Southern and Northern and whatever. There is also a responsibility for every citizen, for every father, for every mother, for every person that is working in the educational system. It will not be fixed, the problem will not be fixed, on this we can be clear, if it's only addressed by the law. The law should help, it should privilege companies that abide by the law, but it will not fix the problem as it has been laid out here. And therefore, I think it will be important for the European Commission in DG Connect and in other services to work closely together, so that the proposal that may come out, as we have learned today in 2026, I hope that I don't say something wrong here, is really moderate, at the same time ambitious on the other, because if we follow some of our colleagues in this house that are always having a dramaturgy which is quite scaring, we won't find the right solution. I think the approach that you have taken, dear Dora, dear Pablo, has been excellent today. It was empathic and factual, and I hope that the EPP Group can continue that way of discussing this important issue. Thanks for organizing it.
Thank you very much again for coming along and sharing your insights and listening. As I said, we look forward to continuing the conversation. Thank you again.